Here are my top 5 rules to not find yourself unprepared in divorce or family law mediation. Stay with me for number 5 because it is the number 1 most violated rule, and people violate it to their detriment. As always, this content is educational in nature. It is not legal advice. For your particular case, seek out a lawyer, and if you have a lawyer, listen to their advice. Number 1, go in knowing exactly what you want and how far you're willing to go to get the case settled. And I don't mean having an amorphous understanding that you want half of your estate or that you want to see your children half the time. I mean very specifically how you want your assets divided. Come in with a spreadsheet that shows exactly how assets are going to be divided between you and your spouse, along with the terms of how it's going to be divided. What do I mean by that? What I mean is, if you're buying your spouse out of the house, what are the terms of the debt going to be? When are you going to pay it? How long do you have to pay it? What is the interest rate going to be? These particulars need to be figured out before you enter mediation. When it comes to time with your kids, what days are you asking for? Specifically, what times? Where are you going to pick them up? You need to have these specifics in mind so that you don't reach a result that simply does not work for you and your kids. Number 2, understand that this is a negotiation, a very important negotiation. So you need to treat it that way. The mediator's only job is to settle the case. That doesn't mean they have to settle it in a way that's fair for you or fair for the other side. They're just doing their job, and their job is to settle. So you need to negotiate accordingly. The mediator is naturally going to pull hard where they see a lot of flexibility, and they're going to spend less energy where they see a lack of flexibility. Now, that doesn't mean that you need to be a stick in the mud. Obviously, that's not conducive to compromise, and that's not conducive to coming to a settlement. But you should not appear overly eager to settle or overly flexible. Yes, you are going to move in your position throughout the day. That's absolutely necessary, and it's to be expected. But it should appear that you're doing so reluctantly and as a matter of compromise. Number 3, understand what the alternative is to an agreement. This has at least 2 components. Number 1, understand well what judges do in your area with the same facts. That's your alternative. If you don't come to an agreement, you're headed to court. You need to know, how does the deal on the table compare to what is likely to happen in court? You're going to need a good board-certified attorney to consult with, or hopefully to represent you, to know this. And the second component is to have some understanding of what the cost will be to go to court. The cost of court is very high. So you're going to want